What's up, y'all? Welcome to the docket presented by Defense Diaries. I'm your host, Bob Mata, and this is my beautiful, brilliant, incredibly sexy co-host, Allie Mata. What's up, girl?
Hey, babe. Hey, all.
Hey, what's up, y'all? Long time no see. Had a great day on the Karen Reed stream. Already in love with that trial. That day just flew by, really did. It was unbelievable. Really looking forward to that whole thing. So, but we cannot neglect the case that never sleeps because we just can't do it. We have to always keep our eye out. And there's been a couple of things, I think, since the last live, and we're going to work our way backwards. Okay. Most recently today, there was a motion in limine that was filed by Nick McClelland. And Allie, why don't you tell our beautiful subs and listeners what exactly is a motion in limine?
It's just where you're asking the court to address an issue before trial and make a ruling before the trial starts that either bars the other side from doing something or allows you to do something. So, I mean, that's generally what motions in limine are.
Okay. And do they differ in any way really from like standard pretrial motions?
Very much so, because they literally deal with the evidence specifically at trial, as opposed to, I mean, a pretrial motion, technically deals with the evidence that's allowed at trial, because if you get something suppressed, but this is like making a trial decision before trial,
Right.
Specifically evidentiary issues and things like that, where a pretrial motion may ask to, exclude evidence because it was, seized illegally. A motion in limine is going to say to, exclude any reference to something because it's more prejudicial than probative, or just like generally inappropriate. Right.
All right. So Nick McClelland has fired the first shot across the bow, and it's a big one. So I think without further ado, let's just jump right into this sucker and see what's up. So this is McClelland's motion in limine, and I'm just going to pound through it. It's short, but potent. You've read this, right?
Me?
Yeah.
Yeah. And then I guess just after each one, just pause and we'll comment on it and then move on to the next.
Okay. So motion to eliminate now. Well, we all know the kind of the general opening clause. Well, I'll just read it. Now comes the state of Indiana by prosecuting attorney Nicholas McClelland, and respectfully requests that the court enter an order requiring the defendant or his counsels to refrain from mentioning in the presence of the jury during voir dire, opening argument, presentation of evidence, and closing argument any and all references to the following, either directly or indirectly. You ready?
Yep.
Ready? All right. 1, any comments about counsel for the state that constitutes a personal attack on the attorney for the state, or comments on the role of the state's attorney. Cite some cases there. What do you have to say about that one?
Well, I mean, typically, it's kind of strange because you don't personally attack any of the lawyers in an opening anyway, but it's like they're really relying on generally things that are complained of about prosecutors, that prosecutors try to make the lawyer sound bad for the defendant, or that the prosecutors try to make some comments that are gonna undermine the defendant's theory. I've never seen something like that. Well, I've never seen anything like that, period.
You mean like when McClelland calls Baldwin and Rosie liars? Would that fall under that category? Like if Rosie and Baldwin, could Rosie and Baldwin write the same thing except about Nick McClelland?
But that is typically how you see this kind of thing. And it even plays out more with the next one. So why don't you move on to the second, and then we'll have a little bit more to talk about.
Okay. So paragraph 2, any comment which constitutes the personal opinion of defense counsel about any evidence, witness, outcome, or penalty. And he cites the Indiana Rules of Professional Conduct 3.4. And then he gives a cite to US v. Young, 470 US. For instance, defense counsel cannot vouch for the truthfulness or competency of any of the state's witnesses, including police officers or any of his own witnesses.
So you can almost see from this, it seems like they might have copied and pasted a defense motion because it's saying that they cannot vouch for the state's witnesses, the truthfulness or the competency of the state witnesses, including police officers. Now, why in the hell in a million
Improper
years
vouching.
would a defense attorney vouch for the state's witnesses? So, and even the case that they cited, it deals specifically with when a prosecutor, is giving their opinions, like a prosecutor's comments during opening statement as to his personally dealings with the witnesses, together with their statements that they were burglars and thieves and courtroom regulars that had been witnesses in prior circuit courts. That's the kind of thing that they are, like not allowed to do. And it violated like the prosecutor's duty. And because that's typically, the situation is like a prosecutor might have prior dealings with people. And it's prosecutors who tend to, try to vouch for their lawyer, their police attorney, their police witnesses, or or their other witnesses. A defense attorney you can vouch for the truthfulness if you think of vouch as just being like you're going to hear from our witnesses who you'll find to be truthful. It's when you start going into, well, I've dealt with this person before and they're a real loser, or something that like that, or where the
loser.
or the prosecutor's like, I work with these police every day. These are honorable police officers fighting for truth and justice, that kind of thing. So again, he's citing cases that deal with things that prosecutors have done, wrong. And I don't know if this is like something standard, but again, the copied and pasted example there literally would be like, for instance, a prosecutor cannot vouch for the truthfulness or competency of any of the state's witnesses, including police officers. It's like they used a defense objection and then added the words or any of his own witnesses.
Right. Yeah. It was kind of a weird one. I like when I read it, I'm like, I don't know what circumstances the defense ever vouching for a cop. Jerry Holman.
Well, that's what
good
they're
guy.
trying.
Good
That's
guy.
why I guess they're trying to do that because they do have some cops on the other side of this.
Oh, Click
to-
and
Right.
Ferenczi and Murphy. Yeah.
Right.
But they're not allowed to vouch for those guys. All right. So 3, any innuendo or inference that is not supported by admissible evidence. Again, Indiana Rules of Professional Conduct 3.4. And then they give a little blurb here. Attorney cannot assert unsubstantiated allegations on collateral matters. Yet another blurb, attorney may not comment or allude to inadmissible evidence during trial. So what do you have to say about that one?
They're taking something that, well, I guess they're saying it anywhere. I mean, it's a little vague, and I think the court's going to want the court cannot or should not grant something that is like just a regular old. Well, I think that all lawyers know that they can't, make reference or innuendos with things that are not supported by admissible evidence. And I'm just going to have to trust the lawyers won't do that. If they have an actual specific thing that they want the court to bar the lawyers from doing, then they need to list that specific thing. These are all general things that no one's supposed to be, supposed to be doing.
Right.
The
Yeah,
court cannot and should not. I'll say that should not be granting anything, like this vague.
Vague booking. All right, I agree. And I think that these are kind of boilerplate. Like they're so broad that there's no specificity. Like I like, to be honest with you, I don't even know what the hell he's talking about. All right, paragraph 4. Any attempt to indoctrinate the jury during voir dire by exposing the jury to substantive issue in the case.
No one's supposed to be doing that.
Yeah, that's like kind of a general rule.
Right. So
Uh,
again, he's just talking about generally indoctrinating the jury during voir dire just means, or voir dire just means like super specific things like about this case as opposed to like general, general questions. I'm trying to think of something, like um if the police stopped an investigation midway and they felt half of the police felt that this thing really pointed to one suspect, but another bunch of hobos thought it should go another route. Well, you guys take that in consideration when you're trying to decide whether or not to believe these police over here who didn't think what these other police believed. That would be indoctrinating them specifically to the facts of this case, as opposed to, will you consider police officers' testimony the same as anyone else's testimony? Are you going to give a police officer, are you going to believe a police officer more just because they're a police officer? Those kind of things you can ask. But once you start getting super specific to the facts of the case, like, well,
it's a no.
if you were to see pictures that look like, ruins or look like some sort of, whatever the case may be, will you take that into consideration when so you can't be that specific, and that would be um indoctrinating the juror. But that's going to be a general rule that the judge, it's not
Right.
supposed to happen anyway.
Yeah, you can't do it. Like the judge will say that. Like I can't remember one situation wherein the judge didn't tell us not to indoctrinate the jury. It's like you just can't start puking out the facts when you're picking a jury. You're not allowed to do it. Paragraph 5.
Again, to go back to like the last one, again, the state is citing cases that point this out about the prosecution not being able to, not the indoctrinating one, but like when you go back to the whole number 3, the cases they relied on are cases where prosecutors were asking questions that were unsupported by the evidence, where you're trying to make, a witness or the defendant, specifically the case they were citing was the defendant, admit to something that there's not even any real evidence to indicate that that is the case. So you're just making, just confusing the jury and making it seem like, you know,
Right. Yeah, exactly. Um, and okay, so 5 is we're still in voir dire. Any attempt during voir dire to have the jury prejudge the credibility of a witness.
I don't know what they're getting at there. Again, you are allowed to make sure that they're not going to prejudge the credibility of a witness. Like I said, just because a cop says something, are you more likely to believe it? Are you willing to treat uh, the testimony from the state witnesses? If you don't believe them, are you going to hold that to them, or are you just going to give them the benefit of the doubt because the state presented them, or because they're a police officer, or because of X, Y, or Z? Those are all legitimate questions. I've never even heard of the concept of prejudging the credibility of a witness.
Like my gut's telling me that the last 3 are all relating to exactly what you said, and that is relating to click. Like they do not want Baldwin and Rosie during the selection of the jury talking about, trying to make sure that if they have a cop witness, that they're not going to give more credibility to the cop witnesses of the state just because they're the ones who made the arrest. That in and of itself, the fact that they're the cops who made the arrest, that they are therefore more credible
I
than
think that's
Click.
fair game. Depending how you ask it, I think that's fair game. Are you going to give arresting officers more credibility than you will non-arresting? Something like that.
Nick doesn't
It,
want you to do it, Allie.
well,
Sorry.
it walks the line between indoctrination and actual legitimate. That is a legitimate bias that needs to be explored, and that's sort of how.
Nick doesn't think so, Allie.
Well,
Sorry.
no.
You'll get nothing and like it. So says Nick McClelland. All right. 6, any hypothetical question or questions that includes facts that are not in evidence or questions that are not helpful in violation of Rule 705.
Again, I mean, this is kind of ridiculous. These are not things you cannot ask the judge to do stuff like that, like just a blanket rule that the whole point of a motion in limine is to present the judge with something that we know is going to come up. We know this specific issue, specifically what 705 issues are you talking about? Where do you think they're going to make, hypothetical, questions? They can't just, I mean, the judge may say, well, all sides know that you're not allowed to do this, so I'm going to grant it and apply it to all sides.
All right. So, and just so you guys have a frame of reference, oh, my door's squeaking open. Disclosing, so Rule 705 from the Indiana criminal rules is disclosing the facts or data underlying an expert's opinion. Unless the court orders otherwise, an expert may state an opinion and give the reasons for it without first testifying to the underlying facts or data. But the expert may be required to disclose those facts or data on cross-examination. So that's Rule 705. So that's what he's talking about there.
So he's specifically referring to hypotheticals posed to an expert.
Right. Exactly.
But it doesn't explain really what specifically he's trying to,
Okay. 6, any hypothetical questions that includes facts that are not in evidence or question. Oh, wait, I already read that one. Sorry. 7, now we're getting to the meat of the matter. Now we're getting to the juicy stuff. Any attempt to introduce evidence of third-party motive that is not relevant and or the probative value is outweighed by unfair prejudice, confusion of the issues, or has the potential to mislead the jury in violation of Rule 401. So do you want to speak on that, or you just want me to read the whole thing?
I mean, it's just, oh, I mean, yeah, I mean, go ahead, read the whole thing.
Okay. So then they have some case cites with some blurbs. Before any such evidence may be permitted, the defense must show some connection between the third party and the crime. That's Holmes v. South Carolina, federal case. Further, it must be a direct connection based on admissible evidence and not founded in hearsay, speculation, rumors, conjecture, or theory. And that's McIntyre v. State, Magaha v. State, and Tibbs v. State. And then Nick gets into some specificity here. And that is specifically, wait, did I go to 3 again?
You got to do that thing where you make it smaller or something. There you go.
Okay, so, but the poor people can't read it then. Okay, so the state requests such order in limine to include, but not be limited to A, Odinism, B, cult or ritualistic killing, C, Brad Holder, D, Patrick Westfall, C, or E, Johnny Messer, F, Elvis Fields, G, Ned Smith, H, Rod Abrams, I, Keegan Klein, J, Jerry Klein, and K, Ron Logan. So there you go with that.
Well, I mean, there is some initial burden that the defense is supposed to have to meet before they can point the finger at third parties, but they can still, get into evidence the fact that there were these things that weren't, what are they asking for? They're saying this at any time, right?
Yeah. So here's Rule 401 from the Indiana criminal rules. So 401 is a test for relevant evidence. Evidence is relevant if, A, it has a tendency to make a fact more or less probable than it would be without the evidence.
Yeah, they should have cited 404B. I think that's what they meant to cite, but sorry.
I think he's relating to the fact that he wants them to prove it up. Like he's which is reasonable, frankly. Like they're always going to make you prove shit up. They're not going to allow you just to throw out a bunch of crazy shit that doesn't have any backing, like that it's got no street cred. Like the question is then going to become, does Judge Gull think the fact that Elvis Fields confessed to two of his sisters to being at the bridge, to leaving DNA via spitting on Abby and claiming that he put sticks around her head and saying that she was difficult, is she going to consider that to be relevant? You know, I mean, I don't know how she doesn't. I think it doesn't go to admissibility. I think it goes to weight. I think that she then tells the jury, well, clearly this gentleman may or may not have said that he was at the bridge. He seems to have some facts. I don't think it's an issue of admissibility. I think it's an issue of weight. But okay, so evidence is relevant if A, it has a tendency to make a fact more or less probable than it would be without the evidence, and B, the fact is of consequence in determining the action. So that's the rule that McClellan cites here. Okay. I mean, what is your like? So this is the one that everyone's going to want to talk about, because this is McClellan essentially trying to shut down their entire theory of defense, saying they can't talk about the Odinism, can't talk about any of the dudes that are known Odinists or prospective Odinists, and that's it. Like, tough shit. You don't get to talk about that. You only get to talk about our evidence, and you can cross-examine our witnesses about our theory, but you can't put a theory forward. I mean, that's essentially what he's asking for here.
Right. But what I mean, I think more what he, like he should be referring to is the standard that the defense has to meet to present third party guilt evidence. And it looks like that might be what they get into more. What I think we might want to do is hit up the rest of this, because we could do just an entire like half hour after our boys at Publicly Buzzed that addresses just that, because it's a lot of legal information that goes into which and what and how each one of those could be admitted.
Okay. All right, so maybe we'll do that. Maybe we should do it for members only. Maybe that should be our first members only thing. All right, paragraph 8. Any reference to an investigation conducted by Todd Click, along with any reports or investigation. I mean, he's trying to say they can't put Todd Click on. No. Any reference to an investigation conducted by Todd Click, along with any reports or investigative materials from Todd Click, that is not relevant or is used for the purpose of confusing the issues or has the potential to mislead the jury in violation of Rule 401. And then again, it's IRE 401, which I just read to you. The
Right.
burden is on the opponent to show why it's relevant. Mullins v. State. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. And then that's Rolston v. State. And then evidence may be excluded if it confuses the issues. Lee versus Hamilton.
The defense has a right to demonstrate that the path of the investigation, how the investigation went, and any investigative leads that they believe weren't followed up on. So I don't see how they can say that, because Click was part of the team investigate, right? I mean, am I wrong? At some point, he was part of the overall investigation, right?
He was never a part of Unified Command. You know, I like he became involved initially, if I remember his testimony correctly, in that he's a Rushville cop. Somebody from Unified Command reached out and said, "Hey," like early on, before they had abandoned this entire line of investigation, and said, "Look, man, can you make a connection between Elvis Fields, Johnny Messer, and like Odinism? Like, can you see if there's a connection between these guys?" And I think that's how he got sucked in.
Well, let me just start in case you decide to do this for members only. Let me just say the case that they cited there, that Holmes, South Carolina case, is a case where the court said that the exclusion of the evidence of the third party guilt in a capital case on grounds that the proffered evidence did not raise the reasonable inference of defendant's own innocence. So they're saying that that was the reason the court gave it. It didn't raise the inference that of the defendant's own innocence, and that the court was focusing on the strong evidence against the defendant. Well, the evidence is so strong against the defendant. This third party stuff, it's not going to, it's not relevant, or they're saying it's not admissible because there's so much evidence that proves the guilt. The court said, no, you need to focus on the probative value of the potential adverse effects of admitting the defendant's evidence of third party guilt. So there they said that the court, like they erred in not doing it. So, and it's not unusual to use a case where the court found that a court was wrong in not putting in the evidence, because then you're going to hear about all the things that the court decided was necessary and the reasons why it should have gotten in. I'm just finding it a little bit surprising that almost all of the cases that the state has relied on are cases that deal with, where this state, in this case, should have put in. The judge erred in not allowing third party guilt, where the prosecution made comments that affected the defendant's right to a fair trial. They're not putting forth evidence that's directly on point, for these issues.
Right. And, I mean, the thing that has to be remembered is the defense has no burden here. They don't have to prove that these guys committed the murder.
Right, but they do have to meet a preliminary burden in order to make the argument or present third-party guilt evidence to the jury. That is true. I was a little bit surprised that hadn't happened thus far, that wasn't already part of a motion in limine filed by the defense to get pre-approval to let that stuff in. But, that's not to say that they can't develop it, during the trial. And
Which again begs the question, have they had enough time to develop the evidence
I sure should hope so.
that they need to get that done? Like, that's like, I'm never trying to rain on a parade here or be like a Chicken Little, the sky is falling, but like, I wouldn't be presenting just facts if I didn't mention that it's a major concern of mine and yours as well. That due to the lack of time, that they may not have been able to develop what they otherwise might be able to develop if they take the time to do it. I mean, it's like preparing for trial. It ain't no joke, and what it means is that, they really have to kind of pick their poisons in terms of what they're going to focus on. It becomes far more myopic in terms of like limiting themselves to what they think is going to be the most effective because of the lack of time. It's that simple. And, I mean, to me, again, the strongest thing that they have connecting these people to this crime scene are the statements by Elvis Fields. And then the question with respect to that becomes, how are they getting those statements by Elvis Fields in? That's what I'm always talking about, you guys. Like, when the puzzles that are involved, the chess match in trying a case is trying to figure out pre-trial how you are going to get certain things into evidence. Trials are not a free-for-all. You don't get just to say shit. It's not the way it works. That's movies. You don't get to do that in real life. In real life, there's rules of evidence, and the rules of evidence are strictly followed. And right now, from where I sit, I was asking Allie today, we were trying to do some, mental gymnastics and figure out, all right, how we getting in Elvis Fields' statements to his sister. He's not a party opponent, so they're not going to come in under that. They are statements against interest. Statements against interest. Maybe there's an argument there. It's like, I mean, there's going to be various arguments that have to be made, but coming into the trial, they have to be preparing these arguments. And I'm sure that they are, because that's the pushback that they're going to get from Gull is how are you? Okay. Gull's pushback was, okay, I'm going to allow for you to put in some third party evidence. How are you getting it into evidence, counsel? Tell me what your plan is. In terms of getting it in, like explain to me, like I'm 5 years old, how you're going to be able to get this evidence in. How are you going to make it admissible? You can't put like police reports are inadmissible. Just so you guys know that you cannot put police reports into evidence.
Right, we can
And
question them about the information that's in the police report.
you can't put police reports in evidence.
You just can't put the report itself in evidence, but they could either call him or the person the statement was made to. It's a statement against interest because at the time, for him to say, if my I mean, the judge would have to decide, and that's why typically that is something that would be addressed in limine. Like like if this was specific, like the motion said, Your Honor, we want you to bar any reference to, although it just has the guy's name. Uh, what's the guy's name who made the statement about the spitting?
Elvis Fields.
Right, and I know now I'm jumping back ahead, but, that Elvis Fields made this statement, then the defense would respond with, "Well, Your Honor, that was a statement against interest at the time that he made it, telling making an excuse to the police for evidence he expects is possible to be found is definitely a statement against interest. It implies knowledge of his belief that his DNA might, could, or will be found." And then the judge would rule as to whether or not he was even a statement against interest, even before you get to the next part. Like that's why Bob's saying, you're supposed to say exactly like the judge is a baby. What are you? How are you getting this in? What exceptions to hearsay are you relying on? What's your, basis for admissibility?
Because
But
that's always the biggest challenge in any trial is figuring out how you're going to get your evidence in. Like whether it's potential hearsay, whether it's documents that are inadmissible. Like it's always the biggest challenge in any trial, trying to figure out how you can get it into evidence. And again, when you have a situation, especially from the defense side of it, where many things are most easily gotten into evidence through the defendant, but you're very resistant to putting the defendant on the stand. It's like those challenges that are presented to the defense that are not necessarily presented to the state are difficult to overcome sometimes, and that's the fact. And Dr. Vonda had asked, but Bob, haven't they laid out the evidence through the Franks motion and other things? Basic information. I mean, we know how Judge Gull feels about the memo. I mean, she hasn't come out and said, I think it's a flaming piece of shit. I think it has no substance. I think it's all malarkey. But she certainly acted like that. I think if the judge thought that this was powerful evidence and she was like, I mean, she sat there through the motion to dismiss. She heard Todd Click testify, credibly. And we're still where we're at with her. You know what I
so
mean? Like, I don't know in terms of what's going to change her mind, other than the fact that there's this looming threat that if she denies them any ability to put forth a third party culprit defense, that this thing's getting kicked back on appeal. I don't know that she can shut them down completely. She's going to have to give them some wiggle room. She's going to have to give them the ability to be able to prove it up, to show her that there's enough there, that there's enough substance, that it's not just junk. I mean, she's going to have to give them that,
right, and
even if it's outside of the presence of the jury.
well, for sure. But their evidence has to do more based on the case that the state cited. The evidence has to do more than just raise bare suspicion, cast bare suspicion, or raise conjectural inferences of another's guilt. And that's typically a decision that the judge makes ahead of time, and it's typically a decision that a lawyer wants a judge to make ahead of time so that they know where the judge sees that they haven't reached that, so they know they're gonna have to do more than this, and it doesn't break up the whole trial, and you're really angering a judge for waiting for something like that, something that big to just, have her rule on the cusp at trial when typically it's something that would be addressed in limine before trial.
Yeah, and like just to answer kind of the baseline question, I'm seeing a lot of people saying, "Oh my God, like is McClellan being just ridiculous?" I mean, no, this was all like 100% to be expected from the defense or from the state. Like like if the state's not filing this kind of motion in limine, they're not doing their job.
Well, on some of the stuff, on the first couple things, they were sort of silly and
Yeah, but
pointless.
who cares about that? Like
Right.
well, I'm talking about the things that matter in the motion where they're getting to the heart of it all. It would be ridiculous for him not to ask for it to be inadmissible. I mean, so no, in that sense, I'm not surprised at all. I would have been shocked if he didn't ask for it. The question is now that it's in writing, which way is Gull going to rule on it? That's what worries us, right? So that's what Allison's saying. I hope they're spending their time getting their ducks in a row so they can go in and make the arguments
This
because
is more than mere conjecture. This is more than mere, like I don't know about this, the burden not being able to be based on hearsay, that they're taking bits and pieces and stuff and throwing it out. But like I said, that requires like so much more analysis. We'll sort of address that whole thing more separately.
all right, so paragraph 9, any reference to geofencing and or any testimony from Kevin Horan about geofencing or the findings from any geofence search that is not relevant or is for the purpose of confusing the issues or has a potential to mislead the jury in violation of Rule 401. And then they cite 401. Burden is on the opponent to show why it's relevant.
Again,
Relevant evidence. So he's just citing the same things here. So again, like the thing that shocks me about this the geofencing thing is he's foreclosing the state in terms of Carroll County from ever being able to use this shit again, as far as I'm concerned. Like, 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 how is he now going to turn around in the next case that comes up, trying to use geofencing to locate somebody near a crime scene? All the defense attorney is going to have to do is go to his pleadings in this and say, What do you mean, Nick? You said this is all bullshit. He said it's not admissible. He said it's like you know what I mean? It's like
not probative of anything.
that's right. It's junk. So it's surprising to me that he's continually trying to keep the geofencing stuff out. It really is. Do you have anything else?
Yeah, just that again, 701 is not 401. Yeah, 401 is like the baseline for admissibility, but he should be citing to different things here. He should be citing to the basis of an expert opinion and just like more sort of specific stuff. But I do think that they're raising issues, albeit very vaguely, very generally, that the judge is going to see as issues that should be addressed, before trial. But you don't ask to exclude, an expert just on 401. I mean, that's like what you do when you can't think of anything else to say. Well, I'm saying it's not even relevant, but you're not arguing why it's not relevant, why it's not probative,
For
but
sure. Okay.
I don't know when this is going to have the hearing. But I mean, to be perfectly honest, I've been shocked that we have not addressed more of these issues before now.
Yeah. Well, I mean, that's kind of like you're shocked. Really? I don't know how you could be shocked at this point. 10, any reference to any prior bad act or acts of a witness that plan to testify at the trial that is not relevant to what the defendant is on trial for, that is not an act, that is an exception to Indiana Rules of Evidence 404B, and that is not both relevant under Indiana Rules of Evidence 401 and tend to negate the guilt of the defendant.
All right. So this ties back to his other thing. Like, really, his argument should have been, as far as third party guilt, that you can't get in 404B evidence of a third party suspect if you can't sort of tie them above and beyond innuendo or, the other very limited reference that I gave earlier for third party guilt. So, such as saying, well, this guy performed um, did performed some sort of kidnapped somebody on a phone. Okay. So like that one, for example, that he kidnapped somebody in the past or something like that. You, there's two different, ways that you can use evidence. There's like using it to show that he's done something wrong. So he might actually have been involved in this, which would encompass 404B evidence. And then there's just impeaching a witness. If the person testifies, then they can be impeached on any bad act that they did that shows bias, that speaks to their bias or their dishonesty, something like this. Um, and you would be able to question a witness about, well, are you just saying this to cast sort of shade and because you're worried that they're gonna, that someone's gonna suspect you or your friends since you guys did X, Y, and Z. It's all about what it's called when you're putting it in and what the purpose for it is when you're putting it in. There's one thing where a judge is going to give a limited instruction that says, well, this can't be used for any other reason but to establish bias or to establish motive to falsely testify. It's not actually evidence that this person may have done something wrong in this case. So, you got to take 10 and tie it right back up to what was it, 8 or 7, where you're talking about third party uh, culpability evidence, because that's really that those two tie in. That's why when he first, I was like, I think he meant to say 404B, not 401. Although again, 401 just encompasses all evidence on the very, very basic level.
Right. All right. And then any reference to this is paragraph 11. Any reference to how the files were labeled that were handed over to the defense as part of the information discovery provided to defense counsel by the state that are not relevant or would tend to cause confusion of the issues or has the potential to mislead the jury in violation of Rule 401. Again, burden is on the opponent to show why it's relevant. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect, and evidence may be excluded if it confuses the issues. So
the judge has to be very cautious about limiting cross-examination. You have a constitutional right to confront the witnesses against you. That includes a constitutional right to challenge the integrity of their investigation. So I don't know what they're talking about here. If they're literally talking about, well, you labeled this like this so that we wouldn't notice it because you were trying to
that's what they're talking about. They're
that?
talking about them trying to, the needle in the haystack thing, that they were trying to hide the entire Odinism angle, bury the lead somewhere in this massive amount of discovery. So that's exactly what he's talking about.
Well, I think it's fair cross-examination. I think it's fair to show bias against them by trying to hide it, by trying to make it less, evident or obvious. But again, it's all going to depend on what the judge thinks, but she's going to be very cautious again. If you interfere with if you limit cross-examination, you've got two sides of the spear. You've got an appellate court that's always going to say it's within the judge's discretion to decide what is going to confuse the jury, what is they're the ones that can gauge credibility of witnesses and, if they think this is important. But the line is just so short when you're dealing with limiting somebody's cross-examination. That's not going to be a harmless error type of analysis on appeal. It's like, no, you went too far and they were not allowed to establish bias. And that's an issue they should have been allowed to establish bias on, even if we give the judge all the discretion that this judge is entitled to have and make. She overstepped. So the judge would have to be, for on that issue. I think it would not be incumbent upon her to limit them from at least, asking it. There's something different about, well, what are you going to do when they say, oh, no, that's just kind of the way we do things. We just kind of did it. Oops. Like that you're stuck with the answer, and that's sort of therein lies the rub kind of thing. But
Right.
yeah, I mean, I don't know. Was that helpful?
Yeah, it was definitely helpful. All right. So 12, any reference to any PowerPoints provided by the state as executive briefs involving any person or persons that were investigated by law enforcement as part of the 6-year investigation into the murder of Abigail Williams and Liberty German that are not relevant or would tend to cause confusion of the issues, or has a potential to mislead the jury in violation of Rule 401. And then he cites the same 4 cases there. So wherefore the state of Indiana, by Nick McClellan, respectfully requests the court to grant the following relief. Order the defendant through his counsel and witnesses to refrain from mentioning, commenting, or making any reference whatsoever, either directly or indirectly, to any of the matters above, without first obtaining permission of the court outside the presence of the hearing of the jury, and to further order said persons make no reference to the fact that this motion has been filed or granted, and all relief just and proper in the premises.
So
So
going
that's
up to that last one that you read,
mm-hmm.
you're dealing with the same. That's
11.
11. What? Go back up because now I forgot what it was. Got to make it smaller and then scroll back into it.
PowerPoints.
Oh, right. So I guess they're talking about where they lined up Logan or other witnesses. I think that all of that is relevant for the purposes of the investigation, that this is a person that everybody called you. You got numerous calls on of people saying, I think that the person you're showing me looks like person X. And then you had an FBI agent do this, and the FBI agent said it was X. So how did you clear that person? Well, we cleared them because of blah, blah, blah. But isn't it true that that they really weren't at work, or that they're, those records can be easily altered, or, you never actually.
Elvis Field's phone was shut off for 10 hours and wasn't moving. Like, they have to be able to get into that on cross. They have to be able to ask those types of questions. Whether or not she's going to think it develops to the point where they can flat out say, we think Elvis Fields did it, is a whole different question, but they're certainly going to be able to delve into those type of issues. I mean, they're going to be able to put enough up to where, the challenge for Gull is, like, how does she land on the fact that Unified Command is more credible than Click, Ferenczi, and Murphy? I mean, just generally speaking, what makes those I have, prior to Delphi, I've never heard that Carroll County was like the greatest investigative unit in the history of the United States, and they've cracked more cases. I've never heard shit about them. And it took them 6 years to get this, and it took them 5 or 6 years to get Rick Allen when they had the same statement 6 years prior. Like, if I'm weighing the competency of the law enforcement agencies involved, I should be able to ask questions like, well, gee, the guy that you have under arrest, you had that statement, the very statement that you're relying so heavily on, buried somewhere, lost for 5 or 6 years. Like, if we're talking about the credibility of the guys who think that somebody else did it, and you're comparing it to the Unified Command, I mean, like, how is Gull, like, weighing that? Where, in what position is she in without more to be able to say, well, I think that these cops are all knuckleheads, because they say this Odinism thing is a thing. Like I think that's nuts. And I'm going to go with the guys who arrested somebody just because they arrested somebody.
So, like one of the examples in the cases that the state cited for, like, not trying to get them to prejudge the witnesses thing, which is kind of what you're talking about here with like click, was that the prosecutor could not ask prospective jurors during voir dire whether they would receive testimony of prosecution witnesses the same as testimony of police officer, despite the witness's conviction for cocaine related charges. Um, so that was them going like a step too far where, they're, and it's also something that people can take into consideration. Well, no, I'm going to take someone who has not been charged with a drug offense's testimony a little more seriously than someone, or less seriously, or believe it less strongly, or take it with a grain of salt more than someone who is a police officer, as opposed to just, like a police officer versus a person. So that the prosecutor couldn't ask, you know, the witnesses whether, um, you know, go to something that specific and then use their peremptory challenges to exclude somebody who is not going to say, I believe a crackhead as much as I believe a police officer, because that's not the same as just determining whether you're going to believe, give the witnesses, either believe or disbelieve the witnesses the same, whether they're part of the, I mean, without using the words unified command versus whatever, that same argument. I think that that would be allowed, although might have to be, worded, carefully worded or crafted to not be indoctrinating them with the facts. But that's not so much indoctrinating them with the facts as just making sure. And I said it before, I'll say it again. I think it's a valid concern that they're not going to give more credibility to police officers who were part of, X line of investigation versus police officers who investigated other sources, that they're going to consider, give them the same weight and judge them the same as to whether they're believable or unbelievable.
Yeah, here's my thing. Like these three other cops from 2018 till Ferenczi's killed in 2021 investigated the shit out of this angle. And they all, to a man, like believed in it. You know what I mean? I'm having a very difficult time seeing how a sitting judge is going to determine that one set of law enforcement officers is credible and the other is not, based merely on the fact that they've made an arrest and nothing more. There's nothing more there. If Elvis Fields had been arrested and say that was by the unified command, just put the shoe on the other foot. Say Elvis Fields, based on his statement that he was there and he spit on the girls, he's now part of a brotherhood and he's got a gang now. And he's homies with these two other dudes. And, it's like, I'm part of something. And they arrest him. And then you had Click, Ferenczi, and Murphy tracking down this CVS pharmacy tech. And they're like, well, this dude was out at the bridge. Like this guy's clothes match. Like we actually have this guy out at the bridge. Like I'm not seeing how she's making a decision where one has more weight than the other, merely because one of them was arrested. I don't know how she's going to deny him that. This isn't like the defense cooking up a theory from their PI that just went out trying to make some kind of tenuous connection. This is like three legitimate cops who investigated for years. And one cop who saw fit to write the prosecuting attorney a letter after, seeking advice from counsel on what to do, because he was so concerned that they arrested somebody that they didn't think fit the bill. You know what I mean? It's like, I don't know. It's like, it's a really tough spot for her to be in, to be honest with you, like, and I don't know how she's making that determination, because whatever case law you read to me right there didn't do it like
Yeah, and
that. Like,
obviously, I'm giving, like, a quick little, a
yeah,
quick little info about the cases, but, and as to Miss Smith's question, judges do it all the time, and, so where somebody says something that really shows a bias, that really shows, like, they're gonna expect to hear from the defendant or something like that, and then the judge just reiterates it and says, "But if I tell you that you can't do that, and you have to just not give any consideration to the fact that the defendant doesn't testify, do you think, even though you said that other thing, do you think you can do that and you can do it fairly and not hold that against him?" And then the witness is like, "Oh, okay," after, like, they just said something that very clearly shows that they want to hear the defendant testify, and they're not going to be satisfied if they don't, or they might take a little bit of a negative inference if they don't, that the judge rehabilitates them with a question like that and then forces the defense to use a preemptory challenge. Happens all the time. So it definitely could happen here. I'm not suggesting that the judge is doing that intentionally to, like, as a scheme to get the defense to have to use their preemptory challenges, all as part of a vicious plot with the state to hurt, you know, to hurt the defendant. It's just something that happens all the time where judges ask the question, and it's like they just want to play make believe, that they don't realize that people just say yes when judges ask questions like that. It's like you basically gave them no way to still say no. So that's why it's like incumbent on the defense to really bring that out before the judge even tries to um rehabilitate the person. Jay's pointing out that I yelled at Bob. So it's
both
I
of us
leave it to
yelled at
Bob
both of
whether he
us
thinks that we should do a separate episode that touches more in depthly on the third party guilt evidence and that kind
wait,
of thing.
in depthly, is that a word?
In depth.
In depthly,
Yes, in depthly.
in
That's the way I'm
depthly.
saying it.
Okay.
Do a more in-depth analysis of the third party guilt requirements and
I mean,
that kind of thing.
here's my issue. I have to get a Garcia thing done before Wednesday.
All right, so we can do it once they're going to have to go to hearing on this, so it'll give us a real good opportunity before that to tell
See, I
everybody what
wanted to read the second motion though, like
you don't
the
have time. You've got to get everybody's got to get over to you got your 7 o'clock
I know, I know. So
public
he
buzz.
potentially criminal. Thank you for that $5 holla. He's not making these motions from a position of strength. He's very worried. Okay, like, I don't disagree that he's worried, and he wouldn't be a good lawyer if he wasn't worried. Like, any lawyer going to a case like this is shitting their pants. That's reality. Any lawyer that's overly confident is probably oblivious to everything that's about to, like, befall them. Like, you go into a case like this, you are crapping your pants because it's as high stakes as you can get. Everything's on the line for both sides. For McClelland, he's got the entire, law enforcement world. He's got the entire, the victim's family. Everybody's relying on him to bring this thing home. And same with Rick Allen's attorneys, Andy and Brad. Like, they are, everyone has more stress upon them than you can ever imagine. And I just want to say this again, anytime that the defense gives notice, in our state, we had to give notice of third party culprit defense. This isn't like somebody predicted that this would happen. Like, there's no way that the state's not filing these kinds of motions in limine. If they know that there's third party culprits, they'd be idiots not to file motions in limine to try to preclude them. Anything that they want to keep out, anything they potentially think that is damaging and or frivolous and or will confuse the jury, they're going to try to keep it out. Period. In every case, not just Delphi. I just want to be clear about that. This isn't some Delphi specific filing.
No, this is something that as we said before, should have been addressed by the defense beforehand, to be perfectly honest, and the state It's a no-brainer that the state would raise this if the defense hasn't moved to admit it. And if you find this, all of you that find the Richard Allen case interesting, there is a lot of crossover, although very different, but a lot of crossover with what's going on in the Karen Reed case. The publicly buzzed guys are covering the openings from this morning now. If you want to catch that, Bob will, what's it
I've
called?
already portaled.
Portaled everybody over,
Everybody's
and
going to
then
get
we'll be there in the morning. We will be covering the hearing
the
live,
trial.
the trial live. So
And I'm
if you
just going to tell y'all, if y'all don't know anything about Karen Reed, it's got all the same elements that Delphi. You've got they're the two cases I'm always talking about. They're the two cases where the defense put their theories out to the world, which doesn't happen ever. And both of those communities exploded and everybody's head blew up. And it
and in
created
that case,
huge divides. And it's the only two cases that I know of where it's happened like that. And they're both, you've got these alternate theories in both cases. In that case, the judge, they're allowed to delve into third party stuff. They've got third party culprits. It's the same thing. They know who they like for it, but they don't necessarily have the evidence. And in that case, law enforcement didn't go inside that house and investigate. So that's why they don't have the evidence. Huh?
The judge hasn't said they met their burden yet to let it in, but it's open for the possibility that they're
They
getting it
haven't
in.
cross-examined anybody yet.
Well, I know. I'm just saying the judge did not make an in limine ruling that they had reached their burden for third party culpability evidence, but she knows what she's expected to see and what's going to change her mind. So I got to go pick up our daughter. Thanks everybody. Go enjoy Publicly Buzzed, and hopefully we'll see you tomorrow.
All right. And then to all of our mods, thank you so much. We love you. If we're going to jump on again, y'all just keep an eye on your notifications. And obviously everybody that gifted memberships and kicked in some dough. Thank you guys so much. We love you. I don't want to step on Steve and Dan's toes, so I'm going to bounce. We love you guys. I do want to read the state's response to the defendant's motion to compel and request for sanctions because it was interesting. So I might jump back on tonight. Keep an eye out for it. If I don't, make sure you're hanging with Jay and I tomorrow on our channel for the Karen Reed trial. I'm just going to say this and then I'm out. Like that full day trial went by in the blink of an eye. It's an amazing trial. It's a great trial. And it's going to be a banger. So if you're not checking it out, you really should. And a good primer, go hang with our friends, Dan and Steve at Publicly Buzzed. Thank you guys for everything, because without you, I'm just an old bastard talking about old and new cases. Talk to you next time.